Assumption of risk is an affirmative defense closely related to contributory negligence. As states move away from contributory negligence in favor of comparative fault, the question arises whether assumption of risk remains a viable defense. In Simmons v. Porter, we explore the intersection of the comparative fault and assumption of risk defenses. Adam Simmons worked as a mechanic at Porter Farms, an agricultural business owned by Richard and Sarah Porter. When Simmons went under one of the farm's old trucks to remove a leaky fuel tank, he noticed that the tank was secured with jerry-rigged fastenings. Simmons proceeded with his work, but the fuel tank tipped, covering him in gasoline. As Simmons tried to quickly extricate himself from under the truck, his foot caught a nearby shop light, causing it to fall to the floor, shatter, and ignite the gasoline. Simmons suffered injuries. Simmons sued the Porters for negligence, alleging that by asking him to work on a truck with an improperly secured fuel tank, the Porters breached their duty to provide a reasonably safe work environment. In response, the Porters asserted assumption of risk as an affirmative defense, arguing that Simmons's negligence claim was barred because he knew the situation was dangerous and chose to continue working. The trial court ruled in favor of the Porters, and the state appellate court affirmed. Simmons appealed to the Kansas Supreme Court, arguing that the assumption of risk defense should be abolished in light of Kansas's adoption of a comparative fault approach to negligence liability.